Good afternoon. May I reserve 5 minutes for rebuttal, please?
5 minutes, yes, ma'am.
Thank you. Good afternoon, Your Honors. My name is Grayson Cannon. May it please the Court of the Nashville Bar. I represent Mr. Johnson in this matter. The factual background of this generally is that these two parties were the heirs and beneficiaries of Jane Dudley. My client, Robert Johnson, was her husband, and the appellee, Ms. Henderson, was her sole child. The parties essentially are involved in a dispute over a piece of real estate known as 4426 Shepherd Place here in Nashville. I'll refer to it as the Shepherd Place property or the Shepherd property. Ms. Dudley was one of 5 children of Mrs. William J. Anderson, who was the original owner of Shepherd Place. Ms. Anderson died in 1986, and her will disposed...
Well, Ms. Anderson wasn't the owner of Shepherd Place, was she? She just had a beneficial interest in that property?
Well, her will says I'm the actual owner, and I believe that she was, and that's what I would submit was the case. She was the actual owner of the property. The trust, as I'll explain, was sort of a construct, perhaps having to do with the fact that she was a widow and the period of time in which she was widowed. For whatever reason, they had placed legal title in a so-called trustee, but the trust wasn't really a trust. The trustee had no duties or responsibilities, and she was actually the owner.
But the deed for the property was not in her name, Mrs. Anderson's name. It was the name of her son as trustee.
At the time of making of her will, yes, I believe it was correct. So the question is, did the language of the will create some kind of trust, like a testamentary trust, or did it simply create a life estate in Mrs. Anderson's daughter, Mrs. Landstreet, with a remainder interest to all 5 of her children or their children per stirpes? And then, of course, there's the question of whether that interest to Mrs. Anderson's children vested at Mrs. Anderson's death, or it was some sort of contingent remainder. The parties to this case ended up having differences over the administration of Jane Dudley's estate. They entered into a settlement agreement to resolve that estate that does not mention the Shepherd Place property at all, although it is expressly mentioned in Ms. Dudley's will, which is part of the record.
Counsel, is it your position that the Shepherd Place property is an asset that Ms. Dudley, I'm making sure I get some of the foundations down here,
Sure.
right? With regard to vested and contingent, you're saying that the Shepherd Place property was owned by Ms. Dudley at the time of her death. It was one of her assets at the time of her death.
Yes.
And is it your position that the will did not bring the property into the administration of the estate? So it's not estate property. Is that a fair description of your position?
Yes, it is. It did not bring the property into Ms. Dudley's estate.
Okay, if that's your position, then why doesn't the settlement agreement resolve this? Because the settlement agreement says the only assets owned by the decedent at her death are the McCrory Lane property and the tangible property. And regarding the residence, says the will did not contain any provisions bringing the residence into the hands of the co-administrators for administration. So it sounds like your position is that this property is essentially identically positioned as the McCrory Lane property. And if so, I'm struggling to see how it wouldn't fall within the scope of the settlement agreement.
Well, if it had been part of the estate, then it might have fallen within the scope of the settlement agreement, except that the settlement agreement didn't mention it whatsoever.
Is there language in the settlement agreement that limits it to property that is within the estate? And the language of the release of claims is extraordinarily broad, and I was wondering if you're waiving your auto accidents against each other in terms of the reach of this. So, and what language would you point us to in this settlement agreement that suggests that it is as limited in scope as being to the estate.
I would point to the recitations at the beginning of the agreement, which talk about what's in the estate and what we're dealing with here.
But isn't this whole settlement agreement addressing the McCrory Lane property, which I think we've established you're suggesting is in exactly the same position as the Shepherd Place property? I mean, you're saying it was owned, it's an asset owned by the decedent at the time of her death, and it wasn't put into the hands of the co-administrators for administration, and that's why it's not estate property, you're saying. What's different then?
Well, what the parties are reciting in the settlement agreement is, no, it wasn't part of the estate, but we've already got a deal on that. And so we're going to abide by that deal, and that's going to be part of our settlement. It's expressly discussed. At the time of the settlement agreement, the parties had already entered into a contract for sale, and so the settlement agreement says we're going to go ahead and close on that. So it is different. It's different in its treatment, not in its beginning position.
What do we make of the language, the only assets owned by the decedent at her death were the residence at 8621 McCrory Lane, Nashville, Davidson County, Tennessee, the residence, and decedent's tangible property located on or about the residence? And it seems to me that's a statement essentially indicating that the understanding was that this was contingent and that it wasn't part, that it hadn't passed. But even putting that aside, and how do we get from that language to Shepherd Place not being within the scope of this agreement?
Because the parties didn't have a meeting of the minds about it. It wasn't discussed in the settlement agreement. There's nothing here to indicate that either party was thinking about it. There's nothing in the settlement agreement to indicate that either party was consenting to anything with regard to Shepherd Place. It was completely left out of the agreement.
Okay, if that's the understanding, how do we square that with the release language of whether known or unknown, suspected or unsuspected, arising in contract or in tort or at law, in equity, or in pursuant to administrative rule or regulation that have or could have been asserted by either party or the estate at any time? So I mean, if it's something that they weren't really thinking about it, but they're disclaiming things even beyond what they were aware of at the time, aren't they?
Well, the language is very broad, admittedly, but it also has to be clear that the parties are knowingly waiving those things. And our case law says that the waiver must be knowing. And the recitations sort of contradict that the parties know anything about what they're going to do with Shepherd Place. So I would submit that there is contradictory language that makes it not clear.
So I'm trying to understand the argument here then. You're saying that because Shepherd Place was not part of the estate of Miss Dudley, and the release really had the effect of releasing only claims vis-a-vis the estate of Miss Dudley or against Miss Johnson and vice versa. So how did the interest that Mr. Johnson claimed come to him then, under your conception of it, if it's outside Miss Dudley's estate?
Well, we would submit that it arose because, in fact, despite the contention of Ms. Henderson, the remainder interest from Ms. Anderson's will had already vested at the time of Ms. Anderson's death. And so Ms. Dudley actually owned an interest, a remainder interest in Shepherd Place when Ms. Dudley died. And it didn't matter that she didn't survive the life tenant. Remainders under Tennessee law are supposed to be vested at the earliest possible opportunity. There's a lot of valid reasoning behind that, because otherwise you could have no certainty in the ownership of real estate if remainders were
If I could follow up on Judge McBrayer's question, and maybe I'm misunderstanding, but I thought the question was, how did it come to Mr. Johnson? So how does he take it, if not through the estate?
Under Ms. Dudley's will.
Okay, but he doesn't have a property, he has an interest in the value of
Correct.
the property, not he's not being given the Shepherd Place, he's not the new owner of Shepherd Place, he's taking of the value of Shepherd Place. So how is that not passing through the estate?
Well, because the property itself didn't pass under the estate. Excuse me.
Why wouldn't it be then, if the property itself, I think I see your distinction here a bit, it's the realty or the real estate interest is not passing, but some value is passing to the estate. But if that's the case, and by waiving claims other than the distribution that you acknowledged in the separate document after the settlement agreement, why wouldn't that be a release of the claim then? Because I would look at it and say, well, in determining what I would get ultimately and receive through my late wife's estate, Miss Dudley's estate, I took into account what I thought the value of that remainderment's interest was in the Shepherd Place property. So where am I going wrong there?
Well, if the parties didn't have a meeting of the minds about Shepherd Place, and Ms. Henderson, apparently, as she contends here, thought that it wasn't even vested in Miss Dudley.
Well, but wouldn't that be subsumed within, Judge Huseman quoted the language about unknown claims, and so, yeah, it's not in the recitals that we're talking about that piece of property, but, you know, that's unknown at that point then, I suppose, right?
Yeah, I understand the question, but I think that the parties, and I know my client relied on the recital at the beginning of the agreement as to what he was bargaining around and what the issues were and what the parties were discussing settlement of.
But this stage in the negotiation of the settlement agreement in connection with Miss Dudley's estate, they would have had equal knowledge of the Shepherd Place situation, would they not?
Well, they might have had equal knowledge, but I'm not sure that they understood it to mean legally the same thing. In other words, there was a difference of opinion about what its legal meaning was. Because we have one party contending that it's not even vested, and it can't vest because the life tenant hasn't died, and then the other party saying it is vested, and so therefore there's something there to give away in Miss Dudley's will. And that indicates a lack of meeting of the minds.
Any further questions?
I think I may be out of my original time, so.
You are.
Thank you.
Thank you.
Good afternoon, Your Honors. My name is Taylor Askew. I'm here on behalf of the appellee, Miss Dudley Henderson. There's been a lot of talk about what's contingent, what's vested, testamentary trusts, whether the language in the will adequately creates one or not. Your Honor touched on what I believe is the actual ultimate question before you all, is not whether or not Miss Dudley could have gifted an interest in the Shepherd property to Mr. Johnson, but did she? Did she actually do that under the language of the will? Now, there are a number of principles that I'd like us to remain cognizant of during our discussion, and that's the first is that the whole exercise in looking at wills is to try to ascertain the intent of the decedent. And we have to do that by looking at the language of the document itself. Now, there's two wills here. There's one will that is from what I'll refer to as the grandmother, who is Miss Anderson, and we can put that one aside for now. There's no argument that Mr. Johnson is a named beneficiary in that will. He's not. He doesn't take anything under the terms of that will. Second, we have the will of Miss Dudley. That's the will where Mr. Johnson is named. That's the will where the argument comes from that he has some ownership interest in the real property at Shepherd Place. So there's no question as to what Mr. Johnson is arguing. He's asserting that he has an ownership interest in the real property. He says, I own 10% or half of the 20%, which is equal to 10% share of the Shepherd Place property. As part of that, he cites to various different principles of law that say this is how real property vests in Tennessee. It doesn't necessarily go through the probate estate. It can vest outside. But what he doesn't engage with, respectfully, is he doesn't look at the actual language of the devise in Miss Dudley's will. Now, if we look at that language, this is part of a residuary clause. The Shepherd Place property is specifically listed in one section of the Dudley will, and that's in Article 6. And it says, if my husband, Dwayne Johnson, shall survive me, my executor shall determine the total value of my residence and all money, cash, stocks, bonds, mutual funds, accounts, notes, investments, and other intangible property, including without limitation, all of my right, title, and interest, if any, in the real property located at 4426 Shepherd Place in Nashville, Tennessee. She then goes on to say, and this is important, I give, devise, and bequeath 1/2 of this amount of the global value of all of the things I just listed, to my husband in fee. And then the next sentence, I give, devise, and bequeath all of the rest, residue, remainder of the property, which I may own at the time of my death, real, personal, and mixed, tangible and intangible, of whatsoever nature, wheresoever situated, including all property which I may acquire or become entitled after the execution of my will, to my daughter, Trevania Dudley Henderson. Those two devises are different. Mr. Johnson got value.
And your position then, counsel, is that it passed through the estate, that his interest has to pass through the estate because of it's taking value of the property.
Correct, and it's not so much that yes, because he never got a real property interest. And the reason that that's important, the reason that language is important, is because the argument that that Mr. Johnson's portion of this somehow avoids the consequences of the settlement agreement relies on Tennessee Code Annotated 3-2-103 that talks about real property interests vesting outside or vesting immediately upon the death of the decedent.
But that, I think I follow the logic there about the distinction of what Mr. Johnson was awarded or granted in his late wife's will versus what the daughter was awarded. But do you really even need to deal with Miss Dudley's will to determine how Miss Johnson got her interest? Because
how Mr. Johnson?
not Mr. Johnson. The granddaughter. Yeah,
granddaughter.
Thank you. Henderson, there's too many Johnsons
yes.
in this case. Because you can just look at Miss Anderson's
Correct.
will, right?
Correct.
I mean, so that tells you that you have a life estate, and then after that,
Correct.
to my children that survive, or my children per stirpies.
Correct.
So end of paragraph.
Correct. So respectfully, Mr. Johnson's position, he loses under both arguments. The first position is the language of the Dudley will, his late wife's will, just doesn't give him a real property interest, and because it's part of a global half value here, it doesn't pass outside. It has to go through the probate estate. He didn't get a real property interest, so the Tennessee Code annotated section that says real property interest vests immediately just doesn't apply to him because he didn't get a real property interest.
Let's say we agree with that. How do we get a breach out of that, of this settlement agreement?
So the settlement agreement waives all claims, known and unknown, demands, causes of action, all sorts, against the estate, which would be what he took under, or against Ms. Henderson. They settled that fully and finally. Money was exchanged under the terms of the settlement agreement. Offset, I believe that Ms. Henderson had to pay Mr. Johnson $40,000 some odd to buy back her mother's engagement ring that her father gave. There was an exchange of consideration. As part of that release, there was one set of claims that wasn't waived, and that was to enforce the obligations of the settlement agreement. Now, to Your Honor's point on the contingent remainder and how my client ended up with her interest, we agree. She got it because her mother did not survive the life tenant, and she stepped into her mother's shoes. When Mr. Johnson asserted a claim to ownership of that property after the execution of the settlement agreement, which foreclosed all claims that he could have against Miss Henderson or Miss Dudley Henderson or against Miss Dudley's estate, he has now asserted a claim which required this declaratory judgment action for my client to enforce the obligations of the settlement agreement, which are not to assert any of these claims. The property couldn't be sold absent a declaration from this court or the trial court, to be affirmed hopefully by this court, that Mr. Johnson does not have an interest in this property that he now asserts.
So the settlement agreement not only waives claims, but you're saying it includes a prohibition against asserting claims.
That would be, and the reason for that, Your Honor, is because if you look at the language of the release, the only claim that survives the release are ones other than to enforce the obligations contained in this agreement. And in order to enforce an obligation contained in this agreement, which would be that all of these claims are released, this declaratory judgment action had to be filed.
Okay. Maybe make it a little more simple for me. What language would you point to in the settlement agreement and say, okay, this is what was breached?
Section 10, I believe it's technical record 47, release of claims. Once the payments described above have been made, the parties release the estate and each other from any and all claims. For purposes of this agreement, the term claims means any and all actions, but then it skips some, and demands.
Okay.
And when Mr. Johnson stepped forward
and made that claim. Okay, you're saying that, all right.
Because, Your Honor, the 10% that's at issue is still in an escrow somewhere. I believe it's actually been paid into the court now, but it hasn't been distributed because he's asserted this claim. She has been prevented from taking what, under her grandmother's will, the property that went to her upon the death of the life tenant, because Mr. Johnson has stepped up and said, I didn't get everything under the Dudley will, even though I've released everything and I've signed under penalty of perjury that this has been probated appropriately and I've received everything to which I'm entitled. And so for that reason, Your Honor.
In terms of the release here, though, it doesn't ultimately matter in your view whether this is contingent or vested or whichever route it goes, there's been a waiver.
Correct.
Okay.
Correct. And because if it's vested, let's assume it's vested. Let's assume that Miss Dudley had a vested transmissible interest prior to the death of the life tenant. The question still becomes, did she transmit it? Was it ever given to Mr. Johnson, that interest in the property? Well,
but even before that, there's a waiver anyway, right? I mean, even if he had an interest, he has waived that
Correct.
Interest. So if maybe he was entitled to it all along, but the waiver essentially is I'm asserting no interest.
Correct. And the stated purpose of the settlement agreement was not just so we could close the estate. It wasn't just so that we can check mark and say we've probated this thing. It says specifically this is to avoid additional protracted litigation between the parties. That was the stated purpose of the settlement agreement, was that we wouldn't be standing here 5 years later. That's why they entered into it. It was not a friendly division of assets. This was a contentious probate because of the relationships between the parties. So you are correct. For purposes of vested or contingent, if it was contingent, she never had anything to give him in the first place. If it was vested, she didn't give it to him. 1, 2, he waived it even if she did. And so where does that leave us? It leaves my client standing in the shoes of her mother as the issue of a child who survived the life tenant. And so for those reasons, the judgment of the trial court should be affirmed. And in addition, the issue of breach, not that I don't appreciate the discussion on it, but it was waived. It's never been briefed. It's never been raised at the trial court level that Mr. Johnson is claiming that he didn't breach. It was never briefed. And the case of Newcomb versus Kohler which is 222 Southwest 3rd 368, which is a Court of Appeals opinion from Tennessee in 2006, says that it has to, in order for an issue to be preserved on appeal, it must be properly argued, and a skeletal argument that is really nothing more than an assertion will not properly preserve a claim. The suggestion and argument that there is somehow an appealable issue as to whether or not there's been a breach of this settlement agreement, it's just never been raised. The trial court appropriately found that there was a breach, but to the extent that that were incorrect, it was never raised at the trial court level. And so for purposes of your Honor's inquiries, there's no reason to go down that road because there's nothing in the record to preserve that for your all's consideration. So for all of those reasons, Your Honor, the judgment of the trial court should be affirmed. The language in the wills is clear. It was a contingent remainder. Your Honor hit on something earlier discussing
That happens every once in a while.
Discussing the status of the Shepherd Place property prior to Miss Anderson's death. And if we are looking at language, was it sufficient to create a testamentary trust? Did it actually create a trust? It doesn't matter, because what we're supposed to be doing is we're supposed to be ascertaining the intent of the parties. And if you look at the language in the Dudley or the Anderson will, which is the technical record at 14, it states that Miss Anderson describes herself as holding, as all my children know I am the owner of a beneficial interest in the property, which she refers to as currently being held in trust. She then describes, or then directs her trustee to hold the property in trust for the use and benefit of my daughter, Nancy Anderson Landstreet, during her lifetime, with the remainder upon her death to be transferred in equal shares to my children, with the issue of a deceased child of mine to take the parent's share per stirpes. The reason we know it's contingent is because two reasons. First, at the death of Miss Anderson, there's no actual legal transfer of interest, at least as she understands it, because it stays within the trust. Nobody gets it. The second reason is the trustee who is directed to transfer that interest upon the death of the life tenant at the time of Miss Anderson's death has no idea who those people are. He doesn't know if the children that are in existence at the time of Miss Anderson's death will then go on to survive the life tenant. It's contingent because the class isn't ascertainable at that point in time, and because there has been no transfer of actual ownership, because it remains in that trust document up until the death of the life tenant, it remains contingent. And for that reason, Your Honor, we would ask that Your Honors affirm the judgment of the trial court, and I appreciate your time if you don't have any more questions.
No more. Thank you.
Thank you. Let me address, I guess, first the issue of fees. I would submit that the provision in the settlement agreement simply talks about, in the event of breach, the party not in breach shall be entitled to his or her attorney's fees and costs from the party in breach. So it requires a breach of contract. In this instance, this was a declaratory judgment action that was brought by Ms. Henderson, not by my client, pursuant to an escrow agreement that the parties had entered into. So she brought the litigation. My client did not.
Counsel, what would the appropriate way to handle this have been in your view? Given Ms. Henderson's position here, how should she have done it, if not through a declaratory judgment action?
Well, the settlement agreement itself provides that enforcement can be procured by filing suit in circuit court. She didn't do that. Instead, she entered into an escrow agreement and filed a declaratory judgment action in Chancery. So she didn't follow the terms of the settlement agreement itself. And, she entered into that escrow agreement voluntarily and willingly. It's not like, she couldn't have done that. there was another party to this litigation originally, which was the title agent, and they, pled the funds into court pursuant to the escrow agreement. So they're no longer involved because, they were released once they paid the funds into court. But this is not a complaint about breaching the settlement agreement itself. It's not like my client, for example, didn't give her back the ring that she was supposed to get under the terms of the settlement agreement. He did. Both parties did all the things provided for in the settlement agreement.
Well,
It's
isn't
just,
the release of claims part of the settlement agreement? I mean, isn't that, the intent to avoid protracted litigation and the release of claims is known, unknown, suspected, unsuspected, and isn't that a part of the agreement?
but the fee provision refers to breach of the agreement, and I would submit that that's not, having a dispute about the underlying meaning or whether it covers something is not a breach of the agreement. It's not the same thing. This court recently had a case, I think it came out maybe last week, regarding these types of agreements and fee shifting provisions. And the law seems pretty clear that you have to strictly adhere to the terms of the agreement itself in order to determine and determine whether or not attorney's fees should be granted to one party or the other. Where it's not clear and unequivocal that there's entitlement to fees, then fees should not be granted, because that's something the parties bargained for. It's contractual, it's not statutory, or it's not provided for in case law, and that's the situation here. So I would submit that even if we're dead wrong about everything else, that Ms. Henderson is not entitled to her fees under the terms of the agreement. The other thing that I would address, it may be neither here nor there to the court, but the idea that Ms. Henderson's ownership interest actually stems from Ms. Anderson's will because it mentions a trust. Where's the trust? We haven't seen the trust language. It's not part of the record. They haven't pled it.
Well,
Where is it?
doesn't her interest arise from the fact that Ms. Anderson's will says per stirpes? I mean, why doesn't that get it to her?
That's simply language indicating how it would pass if one of Mrs. Anderson's children happened to predecease her. That did happen.
Predeceased Miss Landstreet, right? I mean,
the child that predeceased Mrs. Anderson also predeceased Ms. Landstreet, correct? But they're trying to argue to this court that that all of the interests of Ms. Anderson's other children, besides Ms. Landstreet, were contingent on Ms. Landstreet's death. Death is not a contingency. It's just not. It can't be. So there's really nothing in Ms. Anderson's will that makes it contingent. So the actual interest of Ms. Dudley stems from the fact that she had a vested remainder interest in that property. And it did exist at the time of making of her will and at the time of her death, even though she didn't survive her sister, Ms. Landstreet. Does the court have any further questions?
No more.
Thank you so
Thank
much
you.
for your time.
Thanks to all of you. Would you call the last case, please?
In re Cedric C. et al.